federal court of appeal says it will hear 6 challenges of the Trans Mountain Pipeline expansion, focusing on Indigenous consultation, but has dismissed 6 others centered on environmental concerns. The decision announced yesterday calls for proceedings that examine the federal government's consultation with Indigenous communities between August 2018 and June 2019. Canadian Energy Executive Dennis McConaughey joined us earlier on the show. He says he's not sure what another round of consultation looks like.
There's going to be some of those Aboriginal groups, most of whom are in and around the Burnaby area, that are most adamantly opposed, only want to see this project fundamentally redesigned, relocated, or not exist at all. So, how does an accommodation occur on those terms? And if that's the standard of consultation, that is a de facto veto, well, we're into some very strange places.
Yeah, the Liberal government has twice approved a plan to triple the capacity of an existing pipeline from Alberta to the BC coast, but the Federal Court of Appeal tore up the original approval last year. Danielle Smith from 770 CHQR joins us this morning to continue the conversation on this story. Danielle, you've got former Alberta Cabinet Minister Ted Morton on your show today.
Yeah, Ted Morton is also an expert on trying to figure out where the line is between the decisions of elected members of legislatures and parliaments and unelected judges. He wrote a great book a number of years ago called The Court Party, saying that the Charter of Rights and Freedoms had essentially handed over a great deal of that decision-making power to the courts inappropriately. And he has a lot to say as well about the misinterpretation that the courts have had on Section 35, which is the section that enshrines Aboriginal rights. There was a lot of discussion at the time, and I don't think that those who were drafting the charter ever envisioned that the court would be making up new rights as you go along. And as Dennis McConaughey said, are we now at a point where the courts have made up the right of a veto for Aboriginal groups? That was never supposed to be the intention when we were talking about rights. So we're going to see if Ted Morton can help us understand a little bit more about this decision. I'm not sure whether I should be mad at the courts or whether I should be mad at the Liberal government, because the court goes through great lengths to explain that part of the reason why they allowed these 6 cases to go forward, they rejected the environmental claims, but accepted the 6 Indigenous claims, because the government didn't put up any kind of defense. They didn't say any justification for all the consultation that has been done. It's just inconceivable, though, that there hasn't been enough consultation. We've been at this for years. There was a round of consultation that the companies did, a round of consultation that the government did. Then they got sent back to the drawing board to do it again. Then they did it again with Frank Iacobucci and 60 others, and over a course of 10 months. So if that does not constitute proper consultation, then we're reaching for a standard of perfection that is unattainable. And that, again, puts us, as Dennis said, in some pretty weird territory. So we're going to talk with Ted to see about whether or not there's a way of getting this back into some kind of balance.
Yeah, how does the government handle it now, since it is the owner of this pipeline?
Well, that's the really tricky part. I mean, number one, you would say that to act as an owner and intervene. When you look at what the Attorney General of Alberta did, the court commended Alberta for putting forward some of the arguments that they did. They said it was very helpful in allowing them to make a determination. So I don't know if that's just sloppiness or if it's by design. Remember, when Jody Wilson-Raybould left office, the last thing she did as Justice Minister was to send out a directive saying that the government, the prosecutor, should not challenge any environment or any claim brought forward by Indigenous groups. And I'm sort of scratching my head wondering, is this the directive that is now in place? Is that any time a case comes forward, the government is just going to lie down on it? If that's the case, we're in for a pretty rough ride, not only over this project, but over any project that comes forward.
Danielle Smith, you can listen to her show starting at 9:30 today on 770 CHQR. Thanks, Danielle.
Thank you.